Welcome, dear learner. You are welcome on this course on SWAYAM platform, Understanding Competition Law, Theory and Practice. And I am your instructor again with you to take a new session regarding the competition law of this particular module. This is the fourth lecture of this particular module and fourth week, on which we will discuss the vertical agreement with the objective the provision of the Competition Act 2002 that deal with vertical agreement have been discussed in length. So we'll discuss the vertical agreement, but before going detail in vertical agreement, if you remember the previous lecture, that means which start in third module or a third week, and we have discussed till the last lecture the anti-competitive agreement, particularly the horizontal agreement and the types of horizontal agreement. And in last session, if you remember, we have discussed the two important topic on the horizontal agreement, which is anti-competitive, that is bid rigging and cartel. Just to remind you, bid rigging means any agreement between enterprises or person referred in subsection 3 of section 3 engaged in identical or similar production of trading of goods or provision of services, which has the effect of eliminating or reducing competition for bids or adversely affecting the manipulation process or bidding. And the bid rigging take place when bidders collude and keep the bid amount at a predetermined level. For example, in a tender of a school bus service, 3 companies submit bids, but 2 deliberately quotes exorbitant prices just to guaranteeing the third potential bidder may wins at the moderate but still inflated rate. This is called the bid rigging. And example of a cartel. Cartel is the most pernicious form of the horizontal agreement, and which is defined under section 2 subclause C, which means the association of producers, sellers, distributors, traders or service provider who by agreement among themselves limit, control or attempt to control the production, distribution or sale or price or trade in goods or provision of service, like fixation of price or allocation of market or for anything. That means the point is, if the association in a form of association, they comes together for the purpose of any anti-competitive practices or activities or conduct, which is for the purpose of fixation of price or restrict the competition, and it may be for their personal gain or taking unfair advantages. That will call the cartelization, and this process is the cartel. So with this, we are moving to next topic, what we are discussing today, that is vertical agreement. Vertical agreement is also an anti-competitive agreement which comes within the section 3 but subclause 4. A vertical agreement is an anti-competitive agreement, what we have discussed earlier many times, but still an agreement where the agreement refer to entities at different level of supply chain. That means if in a supply chain the agreement take place between the different level, that means in a supply chain, if a manufacturer comes in understanding or agreement with distributor, or distributor comes within agreement with reseller or with the retailer, that is the restriction of competition in a market. Unlike horizontal agreement between the competitor, vertical agreement involve parties with a buyer-seller or supplier-distributor relationship, and these agreement can harm competition by controlling price, limiting market access or imposing restrictive conditions. And under the Competition Act 2002, vertical agreements are addressed under section 3 subclause 4, which prohibits agreement that cause or likely to cause an appreciable adverse effect on competition in India. Unlike horizontal agreement, that is like what we have already discussed in a form of cartel arbitraging, vertical agreements are not presumed to be anti-competitive, and their impact is assessed by case to case as particular occasion on the case of case basis, with the interpretation rule what we have discussed in earlier classes, that rule of reason approach. Section 3 subclause 4 of the Act describes agreement amongst enterprises or person at different stages of the production of supply chain in different market with regard to goods or services to be anti-competitive, and if such agreement causes or is likely to cause an appreciable adverse effect on competition. Section 3 subclause 4 of the Competition Act sets out an inclusive list of vertical agreement that, if found to cause an appreciable adverse effect on competition in India, will be held to be anti-competitive and deemed void. If you see the types of vertical agreement, actually vertical agreement is not the agreement having certain types, but the definition of vertical agreement, because vertical agreement is not the term which has been defined. We have already discussed the meaning of vertical agreement because of the pattern where the enterprise or the parties come into agreement at the vertical length, that means on the length, vertical line of the supply. That's why it is popularly known as vertical agreement. And it includes actually the vertical agreement, the agreement which includes within the meaning of vertical agreement, that means tie-in agreement, exclusive drilling agreement, exclusive distribution agreement, or refusal to deal and resell price maintenance. So this is a 5 specific type of agreement which comes under the meaning of vertical agreement. So that we are saying that there are 5 types of vertical agreement known as tie-in agreement, exclusive supply, exclusive distribution, refusal to deal, and resale price management. Let's discuss one by one. What is tie-in agreement? Tie-in agreement is explained in section 3 subclause 4, that is vertical agreement, and A. All the vertical agreements under section 3 subclause 4. So section 3 subclause 4 is common for all types, but A start with the provision A, which is defined in the explanation A to section 3.4, means imposing a condition on the purchaser of goods to purchase some other goods and thus selling goods which is not of the purchaser's choice. Suppose Mr. A is willing to purchase something for the particular use, but what seller restricted him or seller imposed him a condition that you can take this item only if you are taking the another item, that is B. Otherwise, you cannot buy an item that is A. This is like an agreement which is tie-in agreement. For an example, requiring a person to keep fixed deposit with the locker in a bank while allotting him in a locker, requiring a stabilizer with refrigerator. That means you approach to a shop for buying a refrigerator, but what seller imposed you that you must have to buy an stabilizer with the refrigerator, or you must have to take a stabilizer with your LED TV. This is called the agreement which is tie-in agreement. That means requiring of one more item with the item what you actually require is like the tie-in agreement. That means suppose requiring the buyer of car to pay towards servicing of car with the sale price. Instances of gas distributor to buy a gas stove with a condition to the gas connection. You are willing to take the gas connection, but they are imposing if you are taking the gas connection, you have to take the stove. Definitely, that's only in that condition you will get the gas connection. Again, a newspaper publisher requiring subscriber to subscribe to both morning and evening newspaper. You are willing to take the subscription of only the morning newspaper, but you can take the subscription of morning newspaper only when you subscribe the evening newspaper. In that case, you are. Like, the practice is often resorted to the enterprises to use the popularity of a product, that is tying product, to promote the sale of lesser popular product, that is tied product. That means just to promote or for the purpose of promotion or advertisement of a product which is less popular. What they did? They tied it with another item which is popularly or which is popular among the customer, so that it may get popular or at the time spend of time. A tie-in arrangement reduces the elimination competition or eliminate competition. It also removes the buyer's resistance to be enterprises to use the popularity of a product, tying product, and to promote the sale of the less popular product, that is tied product. A tie-in arrangement or agreement reduce or eliminate competition, and it also remove the buyer resistance to the tied product. Again, an example, a printer manufacturer requiring buyer to purchase only its branded ink cartridge. This is like the promotion of tied product while you are interested in the product what you wishes, but on this condition you have to take one other product. In the case of United States versus Microsoft Corporation in 2001, one of the allegations to the Microsoft Corporation was that Microsoft used its dominance on personal computer operating system, that is tying product, to push the sale of its other product, especially its internet browser and media player system, which was the tied products. And it was the case where it was investigated and found. Another interesting case, that is Eastman Kodak Company versus Image Technical Services in 1992. It was alleged that Eastman Kodak had unlawfully tied the sale of service for its machines to sale of its part and had unlawfully monopolized and attempted to monopolize the sale of service and part of such machine. The US Supreme Court observed that the tie-in arrangement in cases, the following question are to be asked. There are certain questions, there are particular 3 questions what Supreme Court of United States had raised and observed that they must be asked at this type of allegation. And the first question was, which was raised by the Honorable Supreme Court of United States, that is whether 2 separate products were involved. That means if the allegation is like that is the tied arrangement, the first question is whether the products, the alleged product, promoted product or actual product are the separate ones. So that the first question is whether 2 separate products were involved. Second, whether the defendant had acquired the tied product to the purchase with tying product. And the third, whether a substantial amount of interstate commerce had been affected. And finally, whether the defendant had market applying these tests. Court held that Eastman Power in the tying product, Kodak is liable for the tie-in arrangement. There is a second vertical agreement, which is exclusive supply agreement. What is exclusive supply agreement? This is also stated and explained in explanation on section 3 subclass 4b, that it means exclusive dealing agreement, and the explanation to section 3 subclass 4 provides that such an agreement includes any agreement restricting in any manner the purchaser in the course of trade from acquiring the otherwise dealing in any goods under than those of the seller or any other person. For example, the buyer asking the manufacturer not to manufacture identical goods for any other buyer without his consent, and producers entering into long-term contract with artists, prohibiting artists from giving performance anywhere else, or a soft drink company barring a retailer from stocking rival brands. These are the example of exclusive supply agreement. There is a case, that is in Jindal Power Limited versus SAIL in 2012, an exclusive supply agreement through a memorandum of understanding was entered into the Indian Railway Steel Authority, that is SAIL. And this resulted in denial of market access to Jindal Steel Power Limited by foreclosing a substantial part of relevant market. From the analysis of market for rail, the said MOU as an arrangement to supply rails on a continuous basis was held rational both on price and non-price consideration, and was therefore held to be not anti-competitive. So, the observation is important what was given in the case of East Kodak case, that is decided by the Honorable Supreme Court. That is a very important argument, and particularly in this case, the court observed in the SAIL case that there must be the exclusive supply agreement. That means that is exclusive, which the impact is like reducing the potential restraint on competition. If it is not, then it is not anti-competitive. The third one is section 3 subclass 4C, that is exclusive distribution agreement. Exclusive distribution agreement means where it means to limit, restrict or withhold the output of supply of any goods in particular area. For example, a distributor not to sell goods of the manufacturer beyond to prescribed territory, and like a car manufacturer granting exclusive dealership right to one entity in the city. The purpose of such restriction is usually to minimize intra-brand competition by blocking parallel trade by third party. And again, the refusal to deal under section 3 subclass 4D. It means any agreement which restrict by any method the person of classes of person to whom goods are sold or from whom goods are bought. Just take an example, any agreement which provides that the franchisee will not deal in product or goods of similar nature for a period of 3 years. And in such case, from the date of determination of agreement within radius of 5 km from showroom amount to refusal to deal. Otherwise, if you remember, under the Indian Contract Act, there are some exceptions. That means restraint to trade is a contract which is wide as in result. But if you remember, under the Contract Act, there are certain exceptions like goodwill. That means if there is a case of the goodwill, to protect the goodwill, sometimes this type of agreement what we are discussing in this particular section, refusal to deal, may comes at a fair argument. But in a general, if any contract or any agreement or any understanding is done between the two or more entities for this type of cases where they will not deal the same nature of goods or product for the particular period or in a particular territory, that is like the refusal to deal. There is a case in United States versus Colgate where US Supreme Court held that refusal to deal is anti-competitive if it is practiced by the dominant firm to enforce anti-competitive practices such as refusal price, resale price maintenance and selective distribution arrangement, that is, it is done with the objective of elimination or impairing competition, not by the way of exercise of discretion as regard selection of customers. And the last one, not last one, but as a pattern of what explained in section 3 subclass 4, that is E, resale price maintenance. Resale price maintenance generally means any agreement to sell goods on condition that the prices to be charged on the resale by the purchaser shall be precise, the prices stipulated by the seller unless it is clear stated that the price lower than those price may be charged shall be deemed resale price maintenance. For instance, suppose there is a book publisher and who sets a minimum retail price for its book, preventing discount, that is like resale price maintenance. A manufacturer Y and its distributor Z may agree that the distributor will sell Y's product at certain prices at or above the price floor, that is minimum retail or resale price maintenance, or at the below a price ceiling, that is maximum resale price maintenance. And if the Z reduces to maintain price due to whatever reason, Y may stop doing business with it. That means in every case of resale price maintenance is to be judged on the basis of its effect to establish its nature. And usually branded goods are subjected to resale price maintenance as opposed to non-branded goods. So there are certain examples, there are a number of the cases regarding the resale price maintenance, which I will discuss. The related case to the abuse of dominance or the horizontal or the vertical agreement. There are some cases which involve all the issues in the same case. We will discuss in the event when we will discuss that particular topic. So, there is a case which is very much relevant to this particular case. Otherwise, Sri Shamsher Kataria and Honda Steel India is a very popular case in even in section 3 or section 4 also. But still, in this particular event, if you see this landmark case, the informant alleged that Honda Sail Cars Limited and other car manufacturer restricted the sale of spare parts and diagnostic tools to authorized dealers, limiting independent repairs access. The Competition Commission of India observed that HSCI's practice constituted a vertical anti-competitive agreement under section 3 subclause 4 of the Competition Act 2002. Specifically, exclusive supply and distribution arrangement, the court noted that these restrictions created an appreciable adverse effect on competition by foreclosing the aftermarket, increasing cost for consumer and shifting independent repairs. The CCI imposed a penalty of 2,544 crore on 14th car manufacturers including HSCI, emphasizing that such agreement abused their dominant position in the aftermarket. And this rule or the decision highlighted the CCI's strict stance in vertical restraint and harm competitor consumer welfare. So this is CCI who have to look to the market that there must be a level playing field for every competitor, and to promote competition and to restrict or prohibit any activity which is against the provisions of this particular act or comes within the meaning of anti-competitive activities. One more important case in this regard, Enterprises Solution India versus Hyundai Motor India Limited in 2014. And in this case, FX Enterprise alleged that Hyundai Motor India Limited imposed vertical restraint under section 3 subclause 4, including exclusive dealing and retail price maintenance by mandating dealer to procure parts solely from HMIL and adhere to discount control mechanism. The CCI observed that HMIL agreements restricted dealers' freedom and maintained resale prices constituting anti-competitive vertical arrangement. The court noted that these practice resulted in an appreciable adverse impact on competition by limiting consumers' choice and inflating repair cost in the aftermarket. And a penalty of rupees 87 crore were imposed on HMIL, with the CCI emphasizing that such vertical restraint, when enforced by a dominant player, violate Section 3 subclause 4. And this ruling reinforced CCI focus on protecting competition in downstream market affected by restrictive vertical agreement. So with this, just like a summary what we have discussed today, the vertical agreement, the term actually vertical agreement does not define in the anywhere in competition law, but under section 3 subclass 4 of the act, however, provides for arrangement amongst person or enterprise at different stage or level of the production chain in various markets with respect to production, supply, distribution, storage, sale or trade in goods or provision of services. And such agreements are referred to as vertical agreement and are prohibited under the section 3 subclause 1. The rule of reason is used to determine the nature of vertical agreement, since the definition term use which causes are likely to cause appreciable adverse impact, so that these are the cases where they must be evaluated. There are certain types of vertical agreement what we have discussed today, like exclusive supply distribution, tie-in arrangement, resale price management, refusal to deal. There are some instances what we have discussed today with some examples, illustration and case law. So the definition of each of the vertical restraints is also inclusive, and there could be a vertical restraint when it is not prescribed under section 19 subclause 3, which further provides for the factor that may be considered by evaluating the fact. So with this, I am leaving you with a question for self-assessment, and the self-assessment for you, just take this. Suppose here are two self-assessment illustrative questions, and the question is based on today's session only, and you have to think about it. One is XYZ Limited, a manufacturer of electronics, enters into an agreement with ABC retailers. A retailer where XYZ Limited imposes a condition that ABC retailers must not sell its product below a certain price. Does this agreement fall under the category of vertical agreement, which is prohibited under section 3 subclause 4? Think, and under which specific vertical agreement. So this is for you. And one more illustration for you just to think about this. PQR Limited, a supplier of raw material, enters into an agreement with MNO Limited, a manufacturer where PQR Limited agree to supply a raw material only with MNO Limited and not to any other manufacturer. Does this agreement fall under the category of vertical agreement, which is prohibited under section 3 subclause 4? Just think about these two hypothetical illustration. So for today, this is from my side, and with this I am closing this session for today's lecture, and we will meet in next session with anti-competitive agreements exception, that is what are the exceptions and exceptions are given under anti-competitive agreement. So for today, thank you very much.